This is Michael Popok, Legal AF After Dark. Judge Chutkan still making rulings against Donald Trump in the D.C. election interference case, this time rejecting his efforts to find Jack Smith, special counsel, in contempt of court. What happened? Why are we still waiting for the D.C. Court of Appeals on that immunity decision? What will the Supreme Court do next? Interested? Tune in to Legal AF at our most recent episode. Here you go.
In contrast to what happened in Washington, D.C., where I guess Donald Trump's lawyers wanted to say that by Jack Smith even filing documents on the federal docket in that Washington, D.C. criminal case, while Judge Tanya Chutkan, the federal judge presiding over that case, and just as a reminder, this is the case of Trump's effort to overthrow the results of the 2020 election. There's a stay because Donald Trump is appealing to the D.C. Circuit Court of Appeals the denial of his motion to dismiss by Judge Tanya Chutkan in the district court of his claim of absolute presidential immunity. You know, by watching Legal AF, there was oral argument. As of this taping, there still is no ruling by the D.C. Circuit Court of Appeals, but Jack Smith, even while there's been what's called a stay that was issued by Judge Tanya Chutkan, and I think it was debatable whether she should have even issued a stay in the first place, but I'm not going to go into that analysis here. I've done that in other videos. The stay pauses the proceedings, freezes the proceedings pending the outcome of the appeal, and special counsel Jack Smith said, look, I get that. I'm going to voluntarily file some documents about some witnesses, some motions in limine. Trump, you have no obligation to respond to it, but I'm going to file this so that once we prevail in the D.C. Circuit Court of Appeals and they find there's no absolute presidential immunity, let's get the show on the road and we can get started. And then Trump, you can respond to everything we filed. Trump's lawyers basically said, this is so burdensome to us. We don't want these documents filed on the docket because the stay means that we shouldn't even be burdened by having to read these things, even though we don't have to read them. Just stop the filing, please. And you're turning the docket into a PR effort against Donald Trump by filing documents about the case or something like that. That's how the argument went. And they said that that Jack Smith should be held in contempt. So Popok, tell us what the D.C. what Judge Chutkan ruled, what she hinted about on the trial date, and also not having a ruling yet from the D.C. Circuit Court of Appeals. I mean, if it doesn't drop next week, I thought it would happen before February 1. I frankly thought probably on Friday we would get a ruling from the D.C. Circuit Court of Appeals. So Monday, Tuesday, Wednesday, I would certainly expect it. But with each day that passes, I think that signals that, they're either writing a long opinion or there's not full agreement on that panel.
Agree with all that. Let me pick up with that and back into the trial date. I was accused on one of my hot takes of burying the lead about the trial date because it was sort of buried within the order on the motion for contempt. Donald Trump seeking to have the book thrown at Jack Smith's team being found in contempt because of what was the contumacious conduct that, as you said, despite the fact that judge had stayed the case pending the resolution of and getting a mandate back from the D.C. Court of Appeals on whether presidential immunity applied to dismiss the indictment based on his alleged criminal conduct while president, that she made it clear what the parameters of that were, what the contours of a stay was. And she found that the Jack Smith team did not, by serving the other side with discovery they don't, the Trump side have to look at, by putting things on the docket in motion practice that were not required by her and do not require a response by Donald Trump because the case is stayed at the moment. A pin has been placed in the case. She's not going to find contempt. And for clarity's sake, she said, let me make it clear. There's no bad faith by the prosecutors. I'm not implying that there is. I'm denying in part and granting in part the motion. I'll get to the granting in part in a minute. But in general, nothing that they did was wrong or improper. It's not about required things. They can voluntarily do what they like, and Mr. Trump doesn't have to respond to that. However, she said, and this is where the trial court delay of trial thing comes it comes in a collision course with the DC Court of Appeals, which you and I both think this train is a little bit late in arriving. I thought it was going to be early last week, not even late last week, and it's not. Talk about that in a minute. But the judge said in her order, I thought that there was enough time when there were 7 full months on the clock for Mr. Trump to prepare his defense. I'm paraphrasing here. But there isn't 7 full months any longer because I put a pin in this a month ago, and we're still waiting for the DC Court of Appeals to render their decision. And she didn't take the next step and say, and therefore the March trial date ain't happening, but she basically said the March 4th trial date is not happening and that she's going to have to tack on this additional time because she's taken the position that 7 months is enough, but not 6 months and not 5 months. This is like the old joke from Something About Mary, 10-minute abs, 7-minute abs, 7 months is barely enough, but she said it was enough. 6 is not, and 5 is not. And so she's going to have to tack on time. And she says, and then this is different than I said. I said, I thought they need to be preparing just in case they lost. The federal judge actually said that she did not expect them to be preparing for trial at all or having any burden on them while the stay is in place. So when we get this final, and then on the granting of the slight granting to Donald Trump, sort of like ice in winter, she said, on the motions that you're filing, I love this because it's just going to create more work for Donald Trump. Why don't you make a request? Why don't you ask me for permission to file the motion? Which means Jack Smith's going to ask for permission, and Donald Trump's going to have to brief the issue about whether there should be permission, which is doesn't want to do, which is he doesn't want to do any work in the case. But the judge says, do that. I'll take a look at your motions. I'll decide whether they're corollary, kind of on the side of the appeal, if they're at the heart of the appeal, and so you do that. So it was like a win, but not really, because Trump is going to have to be burdened now with litigating over each motion that Jack Smith wants to file, and he's going to do it. Now, in terms of the DC Court of Appeals, you and I think, came to the same kind of conclusion back and forth in preparing for the show, which is my guess and yours is that Judge Pan, who, big hearts go out. We love Judge Pan for many, many reasons, especially as masterfully as she conducted that hearing of the 3-judge panel. I don't think this is a problem of Judge Pan and Judge Childs, the 2 Biden appointees, trying to reach a conclusion about whether presidential immunity absolute, as they like to say on the Trump side, applies to dismiss the indictment of a criminal president, in this case, an indicted or alleged criminal president. And what do you do about an alleged criminal president? I don't think it's those 2. I think that it's Judge Henderson, who is the George W. Bush appointee. She was the one that wanted to delay the oral argument, didn't agree on setting it as early as it was set. And she's the one that recently joined with a very small minority of 4 or 5 people on the DC Court of Appeals during an en banc decision, which is all 12 members in this case of the DC Court of Appeals, making a ruling about whether, for instance, Twitter should have been found in contempt and sanctioned because they wanted to tip off Donald Trump, which violated a court order, before they produced all of Donald Trump's Twitter account and DMs and unsent tweets and whatever to Jack Smith to be used in his indictment and his investigation, which he ultimately did use. That issue, the appeals court said that Twitter was wrong and has to pay $500,000 because they should have not delayed and dragged their feet in producing those documents, and they didn't have a First Amendment right to tip off Donald Trump. They asked for a full panel hearing, all the members of the DC Court of Appeals, and 4 of them, led by I think a Trump appointee, wrote a kind of a scathing dissent, even though the en banc majority approved the trial court's decision ultimately, and said, basically, the Court of Appeals here doesn't really understand executive privilege and how presidential privilege works, and which is weird to say since this is your day job, as the D.C. Court of Appeals is dealing with things related to government and the branches of government. And she joined that, Judge Henderson. So my gut is this is such a momentous decision that Pan would like to have a 3-0. But I think at a certain point, time is against us here, and perfection can't be the enemy of the good enough. And I think she's just going to have to take her 2-1, write that opinion, get Childs to agree to it, and let's get the decision done, because we've got the Supreme Court and that process. Whether that takes a month, 3 months or a week that has to get started, but we can't start until they get out of the starting blocks with a decision at the DC Court of Appeals. So Chutkan upheld again. I mean, Chutkan will be upheld again. Chutkan again made the right decision, and we're just waiting on. And you and I are we're carrying our microphones everywhere, waiting for the DC Court of Appeals to make this historic decision, which we are pretty confident is going to be that a criminal president does not enjoy absolute immunity from future indictment after he leaves office or even when he's in office.
Yeah. And I think that one of the things also could be that they are writing a lengthy opinion. That's kind of one, because they understand the magnitude of this decision. Number two, they could be grappling with whether they do the rule on the issue of jurisdiction or go to the merits, and they're kind of doing some research. And I think they want to get to the merits, but I think they're even kind of digging into the case law about if they don't have jurisdiction, can they still basically say under Midland Asphalt, that 1989 Supreme Court case we've been talking about here, about interlocutory appeals have to be rooted in kind of the strict text of the Constitution or a statute that specifically provides for an interlocutory appeal and absolute presidential immunity. Those words don't strict textually appear in the Constitution, nor is there a statute. So do you just reject jurisdiction and that's kind of it? Even though there are these broader, more significant fundamental issues that they want to get at, and can they get at there and use some sort of ancillary jurisdiction, which they talked about during oral argument, to still get to the merits? And I think that's what's bogging them down. I mean, you figure you're 10, 11 days out, of that oral argument, and I expect a ruling to be very, very, very imminent. But we'll keep everybody posted there, which means, though, that I think that Manhattan District Attorney case, March 25th, becomes the first case to go to trial for the hush money payments Trump made to porn star and then put it on his books as legal fees. And it was a false business record, felonies that Trump can be convicted of. A very kind of simple, streamlined case to kind of put on. And so we will.
Who do you think tries that case for Trump? Susan Necklace, and who else?
Yeah, well, Takapina is not there, so
right.
It'll be Susan Necklace, and I forget. There's one other lawyer on her team. Trump has good lawyers in that case, but it's the same team though that represented the Trump organization.
I think it's Blanche. Todd Blanche showed up with Necklace at the arraignment.
That's who I was thinking of. Yeah. Great call. But it's pretty much the same team though. That was representing the Trump organization. People forget about this. The Trump organization was convicted of felonies last year.
17 counts.
17 felonies. The chief financial officer pled guilty. So that team had lost before a Manhattan jury. But it seems like that one goes first. We play out the remaining issues on the appeal of the Washington, D.C. case. When a mandate finally issues, will the Supreme Court take it? And that, the Manhattan District Attorney case, you probably get a verdict. Jury selection is going to take a little bit of time there. So, but the case itself is fairly simple. So maybe end of April, you'll get a verdict in the Manhattan District Attorney case.
Yeah.
And then we see what's happening in May and June.
Well, if you like lawyers who know what they're talking about at the intersection of law, politics, and justice, come to the right place on the MeidasTouch Network. Free subscribe, help them get to 2 million. And join us on Wednesdays and Saturdays at 8 p.m. Eastern Time for Legal AF. It's exactly what you think. We curate a 1-hour podcast at the intersection of law, politics, and justice and give you that analysis without blowing smoke or sunshine, so you don't have to. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.